What's up, guys? Brian Fellow Law Group PLLC here with your Florida Law Weekly Case Update. Hope everybody had a wonderful holiday break. We're back at it here with some fresh new cases. These are actually from December. The appellate courts had the holidays off too. So let's get right to it. We got a couple celebrity cases. First one is, remember Michael Flynn, the general that was worked under Trump very briefly. Anyway, he sued somebody for defamation because of one of their posts on social media. Posts on social media claim that he was a, quote, Putin employee and that he was a member of QAnon, which is, I guess, I don't know if they're a terrorist organization, but basically an organization that he felt was not very good to be a member of. Anyway, so he sued the defendant for defamation. The defendant ended up winning on summary judgment because for a couple of reasons. First of all, they said that the quote that he was a Putin employee, that was non-actionable rhetorical hyperbole or opinion. So basically, in connection with the way it was posted with an article that was linked, and it was sort of like he wasn't actually saying he's literally a Putin employee, like he's on Putin's payroll and he gets paid, but more like he was in bed with the Russians, kind of. He was sympathetic to the Russians along those lines, and no reasonable person would really believe that he was an actual Putin employee. And so the other thing is with respect to the QAnon comment, the court basically said that, well, first of all, Michael Flynn never actually said, hey, I'm not a member of QAnon. So he never actually put forth evidence, summary judgment evidence in opposition, saying, I'm not actually a member of QAnon. And so they also said that this was a statement that's really not capable of being proven true or false. Like, who is an actual member of QAnon? Is it really even an organization? Or what really is it? And so for those reasons, the court found, hey, Mr. Flynn, you failed to adequately defend against the summary judgment motion. Summary judgment granted. So Michael Flynn's defamation case tossed out. Next case, also celebrity. And again, these aren't really family law cases. I'll get to a few family law cases soon. The second case on appeal involving a celebrity, it involved the musician FloRida. It looks like it's Florida, but it's FloRida. Anyway, so he won at trial. He won big. I don't know if anybody remembers this, but at trial he won a lot of money. Basically, he was an endorser. He had an endorsement deal with Celsius, the drink, the drink. So basically, he had a deal that he would get, instead of getting paid salary or money or something like that, he would get stock in Celsius if they hit a certain number of units sold and things like that. And he said, yeah, I should be paid my stock, but the company failed to give it to him. And so he won at trial. He won millions of dollars. And on appeal, the only thing the appellate court reversed was the amount of damages. Appellate court basically said, so when it's an issue of stock case, your damages are as of the breach. So, and this is a breach of contract case. So the damages should have been as of the date of the breach, which was sometime before, I think it was in 2021 or something like that, before the date of the trial. At trial, the jury and the appellate and the trial court awarded damages as of the date of trial based on the stock price at that time, which apparently was much higher. So the appellate court said, no, remand, you got to calculate the damages basically as of the time of the breach, which was in 2021. So they're still going to get some money, but maybe not as much. The next case is an actual family law case. This was a modification, post-judgment modification, and a divorce. And I thought this one was interesting because it shows a dichotomy in what is sufficient to get a modification. So to get a modification of child support, all you really need to show, according to this case, is Gonzalez versus Calles. All you really need to show is that the payor's income increased. You really don't need to show anything else. That is sufficient to get an increase in the amount of child support. So in this case, the payor's income had doubled since the date of the divorce. And so that was sufficient. They didn't really have to show that the child's needs increased or corresponding like that. The father's increase in income was sufficient in and of itself to warrant a modification. Now, contrast that with the father's counter petition to modify the timesharing. So the father said, hey, I'm doing better financially, and guess what? I bought a house. when at the time of the judgment of the divorce, the father was basically probably living in like an efficiency, and so he didn't really have a sufficient home environment for the child. And the father says, guess what? Now, since the judgment was entered, I'm now living in a better house. I got a big house, and I'm remarried, and my new wife will be able to assist me with the child, the child rearing responsibilities, taking the kids to school, things like that. Whereas before, he wasn't able to do that. And the court basically said that's not sufficient. That is insufficient. The betterment of the non-custodial parent's home is not sufficient to modify time sharing. The fact that he got a bigger house and he increased himself, he made himself better, so to speak, as far as like he made more money and now he's got a better home environment. That's insufficient in and of itself to warrant a modification of time sharing. So it's kind of like heads I win, tails you lose kind of a thing where the if you make more money, you got to pay more child support, but you can't get a modification of time sharing just on that basis alone. The next case is a paternity case. This is Leonard versus Gordon. This again has to do with the dependency exemption. Tax season's coming up, so it's very important. So if the trial court does not award a division of the tax dependency exemption, i.e. say like, okay, father, you're going to get the dependency exemption in even years, mother, you're going to get it in odd years. If the court is just silent, and that's what happened here, the court was explicitly said, I'm not going to deal with this issue. I'm not going to, award either way. So if the court is silent, by default, that means the parent with the majority time sharing gets to claim the tax dependency exemption. So in this case, the court actually said it was going to not rule on dependency exemption, but then in the judgment, it calculated child support as if each parent was able to claim the child as a dependent. Well, so that was not proper, and it made it look like, well, maybe one of the father can also claim the dependency exemption. So that was reversed, and no, it goes to if the court is silent, orally the court says, I'm not going to rule on this, and the judgment is otherwise silent. The parent who has majority time sharing gets to claim the tax dependency exemption. Last case is Savage versus Bustillo. This is a domestic violence stalking injunction case filed by a son and his wife against his own mom, the grandma. So I call this the annoying grandma case. Wouldn't it be nice if you could just file an injunction petition and get an injunction against your mom or your child's grandma because she's being so annoying? So that's kind of what happened here. Basically, there's some family drama, and the grandma was just constantly contacting her son and her daughter-in-law. I think it was something like 20 times in the 6 months for the daughter-in-law and like 50 times in the last 6 months for the son-in-law. I mean, for her own son. And the mother even went up and she enrolled her. She had a minor child too. So she enrolled her minor child up in northern Florida in the same like ballet dance class as the son's daughter. So basically kind of like following him up there. And essentially the appellate court said that's not enough. That's just not enough. You couldn't show that a reasonable person, an objectively reasonable person, would suffer from substantial emotional distress as a result of those kind of actions. Just not sufficient to warrant an injunction. So, guess you're gonna have to deal with your annoying mom and the child's grandma for a little bit longer. Oh well, too bad. Anyway, guys, thanks for staying with me for the first post of the year. Hope everybody has a great new year. Happy New Year. Let's do it.